Remember, under our very rules, hindi ko nababasahin para mas umikli. In our very rules, the presiding officer can decide on the spot, or he can throw it to the body, or he can call a caucus or whatever you call it to be able to decide. And we experienced that during the Corona trial, and that's one reason why everyone acclaimed the late Senate President Enrile, not only because of how he carried it himself, but how the consensus and how he carried it with the minority. Secondly, jurisdiction and regularity. The Senate's jurisdiction over an impeachment trial is constitutional. The exercise of jurisdiction must conform to the Constitution, and the Senate's validity adopted impeachment rules. We cannot say we're following the Constitution, then we will not follow the Constitution. If the Constitution and its framers prescribe who shall preside, who are we to change the Constitution here today? We cannot enlarge or diminish the Constitution arrangement through internal rules or through ad hoc resolution. Lastly, due process. Kailangan malinaw po sa lahat ng partido, both to the prosecution and the defense, kung ano yung korte, kung ano ang two-thirds, kung ano ang charges, kung sino magpre-preside. So kung now, during the first day, we're going to change who's going to preside, and it's against the Constitution, what more changes are we going to do in the next few days? Ano ang limit ng pwede natin palitan sa Constitution at hindi? The authority must come from the Constitution or the governing law, not from the vote of a tribunal. A litigant is entitled to have the case heard by the decision maker, designation by law. The law cannot say that ang mag-hear kay Senator Marcoleta ay Sandigan Bayan, tapos sa Court of Appeals natin siya dadalhin. Hindi pwedeng sabihin sa RTC dapat i-hearing si Juan de la Cruz, tapos sa Sandigan Bayan natin dadalhin. Hindi pwedeng sabihin tatlo sila sa CA, pero in this case, nagbotohan kami, isa lang kaming mag-hearing. Proceedings before a judge or hearing officer who lacks the legal authority are invalid regardless of fairness of the proceedings. A judgment rendered by court without jurisdiction is null and void and may be attacked anytime. It creates no right and produces no effect. It remains basic fact that in law, the choice of the proper forum is crucial, as the decision of a court or tribunal without jurisdiction is a total nullity. A void judgment for want of jurisdiction is no judgment at all. All performed pursuant to it and claims emanating from it have no legal effect. Tan versus Cinco, GR number 213054, June 15, 2016. Penned by Justice Perlas Benabe, First Division. The constitutional authority, Mr. President, is very clear. Now, let's put that aside for a moment. But we're not allowed to do that. But for a moment, let's put that aside, that the Constitution is not clear and does not tell us what to do. The rules of the Senate says that any amendment should be presented a day before. And that's why the then minority, when I was Senate President, walked out, because your contention was, when we gave it to the Committee on Rules, kahit mahigit isang araw na at binabalik ng rules, we did not follow the rules. So on the rump session or alleged rump session on June 3, first of all, you did not have a quorum of 13. But let's assume for the sake of argument, I'm not giving you that point. As far as I'm concerned, it's in the Supreme Court, walang quorum on 12. Assuming may quorum on 12, you did not follow the rules. There was not a one-day notice for the rules. And then if you look at the records, this impeachment court adopted the rules on May 18. So that means that it is this impeachment court that now has to adopt any amendment to the rules. We did not debate that amendment to the rule. We cannot now just change the rules. We're here for the opening statements. We're here for the trial. Are we here to change the rules? We're changing the rules here today, Mr. President. So, Mr. President, later on, I'll ask permission to talk about yung two-thirds because both the issue of the presiding officer and the issue of what constitutes two-thirds of all members is a threshold issue. Para maintindihan lang po ng lahat, lalo po sa mga kababayan natin na nanonood, Merriam-Webster, simple definition, a threshold issue is a preliminary question, minimum requirement, or foundation condition that must be met or resolved before proceeding to the substantive merits of a case, project, or process. In this initial criteria, if this initial criteria is not satisfied, further action is typically dismissed or halted. I want to avoid that this impeachment trial will be declared null and void. I want to avoid walkouts. I want to avoid any delays, Mr. President. The Senate President is more than capable. He said he is willing. He said he is ready. He has been in many situations in his life that people say you cannot do it, but he is done well. He has studied. So what is the issue? Why do we have to vote for a presiding officer, Mr. President? Why can't we follow the Constitution? So the point of order, Mr. President, is that amending the rules, implementing a null and void rule, and violating the Constitution will endanger this whole hearing, Mr. President. So please rule on the point of order, and I hope that the Senate President, who is more than able, will preside.
Thank you to the gentleman from Taguig. Before I express my views on the matter, let me just put into the record the facts on when we amended Rule 2 of the Rules of Procedure on the impeachment trials. On June 3, 2026, Senator Juan Miguel Zubiri proposed Senate Resolution number 430, and that was adopted during that time. And then, on the same day, the same resolution was adopted and renumbered to Resolution number 40. It was published on June 9, 2026, in the Philippine Daily Inquirer, as well as Malaya. During that time, in June 3, when we amended the rules, everyone had the opportunity to express their views regarding the proposed resolution. And since no one objected, we adopted Resolution number 430 and renumbered it to Resolution number 40. That is anchored on our Constitution, Article 6, Section 3, Paragraph 8 of the Constitution, that the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. So my view to the good gentleman, let me just finish, sir. My view is this resolution has been duly approved, and everyone was given an opportunity to discuss that, to object. However, it was no one objected to that resolution, and it was duly approved by the body. So any discussion regarding this resolution should be discussed in plenary when the Senate convenes as a legislative body. In the past precedents, during the ERAP impeachment, November 15, 2020, the body as well approved the rules of impeachment in plenary. During the Corona impeachment, March 23, 2011, once again, resolution number 39 was adopted in plenary. So any issues pertaining to this resolution should be discussed in plenary when the Senate convenes as a legislative body. So that is the position of the chair and the view of the chair on this matter.
Sir President, first, may I dispute that you used the word fact. It is not a fact that the rules were changed because it is being disputed that first, there was no quorum at that day. Second, if we are going to amend the rules of impeachment for the impeachment trial in plenary under the rules of the Senate, Section 136, second paragraph says, the rules may be amended by means of a motion that should be presented at least 1 day before its consideration. It was not presented on June 2. So, we did not follow our rules. So, a rule that was passed that did not follow our rules, or amendment that was passed that did not follow our rules, is void. You cannot get anything out of it. It is a nullity. So if today we pass a change in our rules and we do not follow our own rules in changing that rules, we cannot follow that rules. Secondly, Mr. President, the impeachment court already adopted our rules. Iba po ang plenary, tama po kayo doon, I agree with you there. Iba po yung impeachment court. So is the impeachment court now hostage or subject to whatever changes the legislative body does, and we will not adopt? Then why did we adopt the rules when we took our oath? We adopted it because the impeachment court is not powerless to talk about our rules. But finally, Mr. President, for the sake of argument, just for the sake of argument, wag na natin tignan yung mga amendments. It's against the Constitution. So can the impeachment court disobey the Constitution? If the Constitution says the presiding officer should be the Senate President, can we now say na no, pagbotohan natin kung sino? Because if we say that we can, what next? Will we add to the articles of impeachment? Will we lower the bar of the quantum of evidence needed? Will we say that baliwala na yung pre-trial brief at bahala na si Batman? So, Mr. President, I thought that's why we have the rules. Because when we have the rules, it dictates fair play. And the rule says it is the Senate President who will preside. So if now we're not going to follow the rules, anong pinag-uusapan natin patas? Anong pinag-uusapan natin due process? Anong pinag-uusapan natin na fairness? It is who we chose as Senate President is a political. So we made our case doon na we would have a more fair. You made your case, you got the majority. Now you got the majority, we will give you all the support, Mr. President. But we have to follow the Constitution. We cannot have a trial where we do not follow the Constitution, Mr. President. I think pinaka-basic po yun. Saan sa Constitution po nakalagay, Mr. President,